The last session will look at the working of tribunals. Vivek Reddy has, we are very grateful to him that he's taken time out from his busy practice to spend the afternoon with us. He will be chairing the panel. And Arun, of course, I mean, we've literally kind of planned this program out. So Arun, since he has published considerably on the theme of tribunals, will be making a presentation, and Prashant has been writing on it consecutively. So without any further ado, in the interest of time,
although the audience is done, I was quite impressed by the fact that on a Sunday, on a Republic Day, with the Indo-New Zealand cricket match going on, I'm quite impressed with Siddharth that he was able to get an audience on this. But that's a lot to be said. Certainly doesn't replicate my law school days. But on, I think he had the same comment last year. So I think the short issue on which this usually comes at the end of the day, but on the issue of tribunals, but I think it's very important for, the issue of tribunals is not just important for academicians, but particularly for law students and lawyers. This is a subject which increasingly our high courts are now becoming courts which just hear criminal appeals and civil appeals, and probably some writ petitions relating to some civil subjects. And all specialized subjects are now going on to a separate branch of the judiciary. Now, this is a compromise. This new judicial architecture was designed way back in '87. Arun has been writing and talking about it throughout my time in law school. He has been talking about it even now. Now, there have been 6 or 7 constitution benches dealing with issues of tribunals. My question to my two panelists, and I would not take long, my question to two panelists is that, is it now time, I'm going against the theme of the conference, instead of reforming, is it now time to abandon this experiment? Historically, we've had, whenever there was pressure on the government to deal with specialized affairs, we would slice executive power away from the government and create an independent regulatory agency, whether it's TRAI, SEBI, or the recent Consumer Protection Authority. So, similarly, tribunals were an attempt to slice judicial power away from our conventional high courts and put it in a dedicated body. 2 reasons were given. These dedicated bodies would deal with disputes with speed and with expertise. Speed and expertise were the 2 clear arguments. 25 years or almost 30 years from now, neither on speed nor on the issue of expertise, they have shown themselves in a remarkable way. On the issue of expertise, we now, after the recent Roger Matthew case, we now have all retired High Court judges. Now the proposal is that, I think, if they perform a judicial body, which a High Court used to perform, we must have the same people sitting over there. So the expertise argument is gone. And now, on speed, the less said, the better. So, with every constitution bench, they have been trying to work in safeguards as to how to make tribunals better. But if at the end of the day, we end up in a system where you have the same functions being performed at the tribunals, minus those safeguards, then is it time to abandon the experiment of tribunals, get these disputes back to the High Court, with specialized divisions within the High Court, like a tax division, like a insolvency division, like the way the English Commercial Court has done. And so that you get these expertise within the High Court and you have the same safeguards provided by the Constitution. The last point before I want to is that Roger Matthews created a special problem. Roger Matthews says, and rightly so, I think one good thing coming out of Roger Matthews was that we can't make the Supreme Court as an appellate body for almost every dispute. You can't short circuit the High Court and say, from the tribunal, I will go straight to the Supreme Court. The Supreme Court is getting clogged even though it is functioning at full capacity. So these disputes necessarily have to go to the Supreme Court through the High Court. That's one critical message which Roger Matthews has given. Now, if they're going to come through the High Court anyway, then do we really need appellate tribunals? The entire point for them was to take them away from the High Court's jurisdiction. So, is the architecture, do we need to redesign and go back and make our High Courts more robust, rather than trying to work on tweaking the tribunals? I think that's the question I have. I have 2 good panelists for you. Prashant and Arun. Prashant has been speaking about this, and Arun has been speaking about it for, as I said, forever and ever. So I hopefully will, but unfortunately, the theme has to remain the same. Sure, Prashant, please go ahead.
Can I switch that slide? Thanks for the introduction, Vivek. And my apologies for inflicting a PowerPoint presentation on all of you, but I generally speak at IP conferences, and if you don't have a PowerPoint presentation, they don't take you seriously. So which is why I'm doing this. And the other reason that I'm speaking at a constitutional law conference is because a few years ago, inspired by Chauhan, I tried to do a PhD at Nalsar while teaching, and the topic was tribunals. I abandoned it very quickly because I found out that teaching administrative law to the present fifth years was a very challenging task. So I withdrew my PhD proposal instead. So since there was only one significant judgment last year on tribunals, which is not enough for both of us to speak on, I'm going to give a bit of a background on tribunals, and then Arun is going to do the deep dive into the Roger Matthews judgment. To begin with, I think it's very important to develop some kind of taxonomy when you're dealing with tribunals, because the way the phrase tribunals is used today, it covers a large number of quasi-judicial and judicial bodies. So just for the purposes of this discussion, I've broken it into three categories. So one is the classic tribunals, which is like the income tax appellate tribunal. These are tribunals which have a right to appeal to the high courts, or under writ jurisdiction there is some judicial oversight. So they're not the last body of determining law of fact, or sorry, determining law at least. The second category are the designated tribunals, what I call them. This is, for example, under the Unlawful Activities Prevention Act. A High Court judge is designated as a tribunal to decide certain issues and make factual determinations. The second category, and even the first category, haven't raised significant issues regarding judicial independence. They've been relatively non-controversial. In fact, even if you look at jurisdictions like the United States, they have an entire judicial mechanism within the government, which is basically administrative law judges who will adjudicate, basically discharge the quasi-judicial function, and once those remedies are exhausted before the administrative law judges, then you can go before one of the Article 3 courts for a significant judicial review. So it's not completely unknown to have some kind of courts within government to deal with one layer of disputes. The third category is what is going to be the focus of our discussions today, which is the judicial tribunals. And by this I mean the tribunals which have taken over the functions of the high courts. So there's this entire, you can see all the abbreviations. So there's a National Company Law Tribunal, National Tax Tribunal, the Intellectual Property Appellate Board, the National Green Tribunal, the Armed Forces Tribunal, the Central Administrative Tribunal, the Debt Recovery Tribunals. So as you can see, there's a large chunk of work which has basically shifted out from the high courts to these specialized tribunals, with the only exception being the DRTs, which took over the functions of district judges. So there's been this wholesale shift which has happened, and the birth of these tribunals basically can be traced back to the 42nd Amendment, which was enacted during the emergency. The 42nd Amendment tackled a lot of issues related to judicial reform, which surprisingly survived the 44th Amendment, which had revoked significant portions of the 42nd Amendment. So it basically provided for two provisions, Article 323A and 323B. One was for tribunals for service matters, because there were two committees before emergency which had basically said that high courts are being inundated with service disputes regarding the bureaucracy, and hence let's create some specialized tribunals for that. The second category of tribunals that it allowed for was wide-ranging subject areas, which I have explained over here. Now, the two important modifications brought in by this 42nd Amendment was first that judicial review of high courts would be excluded. And the second important issue that this was more of an omission by the 42nd Amendment is that they never laid down any criteria regarding appointment or removal of the judges to these tribunals, and there was nothing regarding their qualification, which is very surprising, because the entire, the entire debate about judicial independence in India, whether the High Courts or the Supreme Court is involved, is usually regarding appointments and removals, because those are considered to be the two most important criteria to determine judicial independence. Now, I'll briefly cover why exactly were these judicial tribunals created. Now, the conventional logic would basically say that it was to deal with delays and pendencies. That's what the Swan Singh committee report and some of these earlier committee reports said. The other way of looking at it is, if you look at it from the political perspective, which a lot of lawyers do, is that it was Indira Gandhi who was very miffed with the independence that was being displayed by high courts, that she decided to claw back some power by creating this entirely separate adjudicatory mechanism, which the high courts had no oversight over, and perhaps she thought that the government could exercise more control over these tribunals. The third reason, I think, which is attributed quite often to tribunals, is this procedural informalism. Now, this actually came in after the 76th Amendment. If you read Anuj's book on, quoting the people, he has this entire chapter where in the 80s, starting with PILs and, consumer courts, there's this entire move towards procedural informalism where basically policymakers declared war on procedure, because procedure was seen as something, the conventional rules of CPC and evidence were seen as hampering, cases from being disposed efficiently. And this fails to take into the fact that the courtroom, it's a site of, complex politics between judges, litigants, lawyers. Just tweaking procedural rules actually isn't going to change anything. The fourth justification, I would say, is it was an attempt to try and bring in specializations. So all these new tribunals were going to bring in technical members along with the judicial members, and the idea was for these technical members to provide some kind of technical expertise. And now nobody really knows what exactly that means, because in a lot of cases, for example, in NGT and say even in the IPAB, a lot of cases are basically simple administrative law issues. You don't need a rocket scientist sitting there to provide input on like certain scientific issues. The fifth justification, and this is just a hypothesis, is that I think the central government at some level was very frustrated with the level of progress being made by state governments and high courts in the arena of judicial reforms. Because the way the constitution was originally written, although we had a unitary judicial system, we had a federated system of judicial administration, which meant that every state government had to provide a certain amount of support and funding to high courts to run and reform the civil court system. And perhaps the central government thought it would be an interesting way to just, cut out the middlemen, so to speak, which allowed them the leeway to set up the debt recovery tribunals, etc., which could then be run directly by the central government. And perhaps they thought that would be a more efficient way of running these tribunals. The last justification, and again this is a hypothesis of mine, is that there was a capture at some level by the Indian Legal Service. So the Indian Legal Service is a cadre which runs the law ministry, and one of the interesting things that you will see in all the tribunal related legislation that has been introduced since the Administrative Act 1985 is that it provides for the ILS member, the Indian Legal Service members, to sit as technical members on these tribunals and then eventually get promoted to the position of vice chairperson and chairperson of these tribunals, which gives them a great way to seize power for themselves. And given that these were bureaucrats in charge of drafting these laws, you could argue that there's some amount of conflict of interest over there. Now, to what extent were these tribunals a success? I think everybody will agree that tribunalization has been a broad failure. Even with, I think one of the reasons that this banking crisis is there is because the debt recovery tribunal has been an abysmal failure. Nobody really talks about it enough. We've just created the NCLT and now given it a new role. We have to see whether it can discharge it. Did they bring in expert members, judges? So they did bring in certain amount of expertise in the sense that whatever was there in the statute was complied with. But the way the expert member qualifications were written in the law, these guys didn't actually have any expertise. So for example, a lot of laws allow Indian legal service members or Indian company law service members to be appointed as expert members. And it's not really clear what level of expertise they're bringing into these kinds of disputes. So the other problems that tribunals mainly became a post-retirement haven for judges, bureaucrats. I won't go into that in too much detail. Since I'm running short on time, I'm going to cut it down a little bit. The two unintended consequences, I think, of tribunalization which don't get enough academic attention is the overwhelming centralization of judicial power. And this is on display with the National Green Tribunal. You were in a situation before where you had 24, 25 high courts which could exercise judicial review when it came to environmental issues, could hear PILs, etc. related to environmental issues. And now you've consolidated that into one tribunal system which is essentially run by one chairperson because he's the master of the roster and he has an incredible influence on how jurisprudence in that particular area is going to develop over the next few years. So the NGT, if it has a developmental oriented judge, the kind of environmental jurisprudence that you'll see coming out of it over the next 5 years is going to be very, very different. And that kind of concentration of judicial power is something that we really need to talk about. The last 2 points are it's reduced access to justice in many ways because high courts earlier were very accessible to people in every state capital, especially in matters like environmental law. It's it's NGOs, lone wolf litigants who are filing these matters before the high courts. And now, for example, in Hyderabad, I don't think there's an NGT bench. Now, if this fellow has to go till Madras and file a case over there, it's just not going to happen. And I have a feeling that if somebody does an empirical study, you will find out that it has significantly curbed access to justice. The last point in this slide is the impact on federalism and representativeness. I mean, earlier high courts, the governor had to be consulted while making an appointment to the high courts, and there was a guarantee that there would be people from that state who are sitting on that particular high court. Now what you have with a centralized system of appointments at the central government level is that basically you need to be in the orbit of influence in Delhi to get appointed to one of these tribunals, and there are clear trends that judges from, say, the Delhi High Court are given a preference when it comes to a lot of these tribunals, like the PMLA, etc., which from a long-term perspective is, I think, very problematic given the original constitutional scheme. Since I'm running really short, so there has been kind of a crisis of confidence in judicial tribunals, and there's been a lot of case law which has struck down certain tribunals. Now, I just wanted to focus on two last issues since I'm running short on time. One is this it's been a very difficult area of jurisprudence for the Supreme Court because the Constitution provides for these tribunals and there's very little that they could do to try and, strike these down as unconstitutional. So one way they sought out of this is to fall back on the basic structure doctrine to say that you cannot exclude judicial review. And then there's this other remarkable quote in the NCLT judgment where Justice Ravindran basically reads in the separation of powers doctrine into Article 14, which, I would classify it as a bit of judicial gymnastics. Where he says the fundamental right to equality before law and equal protection of law is guaranteed by Article 14 of the Constitution, clearly includes a right to have the person's right adjudicated by a forum, which exercises judicial power in an impartial and independent manner, consistent with recognized principles of adjudication. Now, as a lawyer in the English common law tradition, I really like this conclusion, but I don't think it flows from Article 14. It would be quite a stretch. One way to try and justify this is like Abhinav Chandrachud has written on this 10 years ago, where he says that this is basically an expression of the substantive due process doctrine, except the judgment itself really doesn't articulate it in that manner. The second interesting observation again in this judgment is, I think the judges and the Madras Bar Association were really grappling with getting bureaucrats out of these tribunals, and they couldn't find an interesting enough argument, so you've come up with this rather weird argument where the judge says there may be brilliant and competent people even working as section officers or upper division clerks, but that does not mean they can be appointed as members. Competence is different from experience, maturity, and status. Therefore, when the legislature substitutes the judges of the High Court, the standards applicable should be nearly as equal as the case of High Court judges. And that, according to the Supreme Court, means that you can appoint only secretary-level officers and say not joint secretaries or under secretaries. Now, again, if you're trying to read this, if you're trying to locate this in any kind of legal principle, it's very difficult to actually find any principle, because the joint secretaries are almost the same age and experience as most high court judges would be at the age of, say, 45, 50. So this issue of status keeps coming into this conversation on tribunals. It's there even in the Roger Matthews case a little bit. And I think they're both interesting examples of where, even though I really like the outcomes, if I try to engage with the reasoning, I'll have to admit that the reasoning is very, very tenuous and it's on very, very thin ice. So I'll conclude with this last slide on, there is, I think the tribunal, the adjudication or the litigation over tribunals it's an example of a larger rule of law crisis, because we've had a tradition in India where the legislature circumvents judicial verdicts by coming out with, statutes which remedy the so-called wrong. But what is remarkable with the tribunal litigation is that every time the Supreme Court strikes down a law, the bureaucracy just brings it in with slight tweaks. I mean, they're not even trying to circumvent the judgments in a lot of cases. They're remaking the exact same errors that were made the first time round. And that shows an unwillingness of the bureaucracy to accept the decisions of the court, which I think has long-term ramifications for a constitutional democracy. And I think another way, one of the things I'm really careful about is this is mainly a bureaucratic judicial shift. And the political class really doesn't seem to have any skin in the game, because Narendra Modi, when he became Prime Minister in his last term, he said he can do away with tribunals, they're not working. Like, he doesn't seem to be that bothered with them. He doesn't seem to be so bothered with these tribunals. But there's something happening in the bureaucracy. I don't know if it's an ego battle or something. And the Finance Act 2017 is atrocious in the manner in which it was drafted and the way it tried to seize judicial power. So I'll conclude with this, and I'll invite Arun to do a deep dive into the Roger Matthews case. Thank you.
Thank you. So I'm going to be mindful of time, and I'll try and keep it as brief as possible. So again, in continuation with the theme, I should say there are so the Roger Matthews judgment, which I will discuss briefly, but in the context of tribunals, there's also a ruling by Justice Nariman on an NGT case from Sterlite Industries in Chennai, which also should be considered if you're doing a review. I won't be addressing that, but I also want to talk about something that Nizam spoke about earlier, and I was looking at, as Prashant has said, there's a fairly detailed amount of jurisprudence on how tribunals should be constituted. And when Nizam adverted briefly to the problematic way in which foreigners' tribunals under the NRC process are working, there is an Amnesty International report, since we're talking about law and other things, there's a blog post by my Australian colleague, Douglas McDonald-Norman, on law and other things about the foreigners' tribunals. And I want to just link that up, because it might seem that tribunals are this esoteric technical area of the law, but that law actually should have a bearing on what is happening as part of the NRC process. This is a process that Chief Justice Gogoi, we know, has played a huge role in, but also, this was what Nizam referred to the Holmes, the Arthur Conan Doyle story of the dog who didn't bark, and that's where Justice Nariman's role comes in. Justice Nariman has played quite a significant role in tribunal jurisprudence. I should clarify, given our contempt laws, that I'm speaking metaphorically, but maybe symbols take real form sometimes. But I just want to say that what is puzzling really is, and so I think this has been a theme that has come over 2 days. In the last session, there was this question of how do we square off inconsistency and that. But I do want to say again, this is a bit of a broken record. What we are seeing in the last 4 years, and I think Arundhati referred to it as law and politics being very visible even to non-lawyers, but in some ways this has been a part of the story of the court all along. Right? I don't think the answer is that we just go to text and we'll find answers. This is the age-old dilemma of constitutional adjudication and constitutional interpretation. You try and tether the power of judges. This is what Bickel called the counter-majoritarian difficulty. You try and control them or guide their discretion by having certain rules, stick to text, stick to doctrine, stick to precedent. But for a variety of reasons, in every jurisdiction that you can think of, there is a lot of flexibility, and there is this kind of the contradictions that we see. So in tribunal jurisprudence also you can see that. So we are talking about Roger Matthew, which was delivered last. It's an interesting judgment. I will mention there's an odd thing, since we've talked in earlier panels about judgments, and the Ayodhya judgment, one of the most remarkable features of it is its unsigned character, as Professor Mustafa said. So we don't know who is the author of the, I think we know if you read judgments, who wrote the addendum, but this odd thing of not being signed by any judge. So on that thing, we're talking about all kinds of things breaking down at the court. The Roger Matthew judgment actually, and I should say there are people from CLPR here. They're not in the room right now. Sudhir is walking in. He's also involved in this. The Supreme Court Observer is a great resource, and I've been using it through this conference as well. I would ask you, if you don't have time to read the entire nearly 300-page judgment, the Supreme Court Observer has a good section on Roger Matthew. There are 3 judgments. I don't know what to call it, the principal judgment. It purports to be the judgment of the entire court, right? So all 5 judges sign it. Then Justice Chandrachud and Justice Deepak Gupta proceed to issue separate judgments, which they also sign. So I'm wondering, can I disagree with myself when I write as part of 5 people? And I mean, the idea of a separate concurrence, we know. The idea of a dissent, we know. We know the idea of a partial dissent or a separate concurrence. But how can I sign the majority and then sign a separate judgment where I say that go beyond the majority or things like that, right? So these seem to be odd. Maybe this is an academic point, I mean, but seems to me a fairly important point if you're trying to figure out where the judges are on that point. So so the 5-judge principal opinion holds, and actually a lot of the discussion and why Roger Matthew is probably important is also for the money bill question, which the Aadhaar bench resolved pretty unsatisfactorily, and there's a direct acknowledgement of that by the main judgment. And then, in a tactic which is quite common now, it's been referred to a larger bench. So the money bill question, and whether the Finance Act could also be considered as a money bill, right? So that question they didn't answer. Only Justice Chandrachud answers it, and he says the Finance Act of 2017 could not be a money bill for the reasons that we know he had articulated in the Aadhaar case as well. So that's one reason. There are the Finance Act has rules which seek to govern the way tribunals will be created and appointed, as Prashant said. And I have to say, the first time I noticed this was when Prashant, I think, wrote a piece on a blog, going on about what are the problems of this, and I would still refer you to that if you want a quick summary of what the Finance Act 2017 tribunals did and how they were trying to go from that. So those rules were struck down by the majority judgment. They said we strike them out completely, and they're problematic. There was an argument of excessive delegation because too much power was left under the rules to government officials in terms of how these appointments would be made. The court clearly had sympathy for that argument, but it said that there are actually a whole range of Supreme Court decisions which lay down how those things can be done. So it's not excessive delegation, but that power has to be exercised. So they basically directed that the government draft new rules and said those rules should be in conformity with the case law that the court, as Vivek said, has spent 2.5 decades building this jurisprudence, right? But I feel some degree of sympathy for whoever is going to redraft these rules, because as Prashant has said, it's not as if from this 25 years of case law you can determine very clear principles. So that's the position. So the rules were struck down. on this ground, and they said you have to draft new rules. And in the interim, the principal judgment has an interim relief portion where they say that the situation as to how people are to be appointed to tribunals will be done according to the law as it stood before the Finance Act came into force, and that's going to be the governing law. And if the government has difficulties in appointing tribunal members, it should approach the court for clarification. Right? So in that sense, and as Vivek said, the only thing I'd say to Vivek is the position that you will have to go to the high courts and the 226 jurisdiction is to be preserved is not a new position in Roger Matthew. They're just reiterating Chandra Kumar to a certain extent. It could be I know there's a bit of a dispute about how Chandra Kumar is to be interpreted, but the rationale of that is Chandra Kumar and the long line of cases earlier, right? So the idea that you don't exclude that is important. So that's the Roger Matthew principal judgment. Justice Deepak Gupta disagrees on the excessive delegation point, and his judgment addresses that. Justice Chandrachud provides, I think, a greater basis for the main opinions ruling that these rules are unconstitutional. And then he also has quite a bit to say on how to deal with the problem that Prashant has sort of laid out, right? So the various tribunals, how do you organize them? What are ways to do it? So the principal judgment also says that the government is to conduct a judicial impact assessment of all the tribunals and their functioning. So I guess this is taken from environmental impact assessment studies, and I think there are now, so Vidhi and Daksh and several other policy bodies are doing studies of how these tribunals are functioning. There's a lot of analysis of what are the cases there and how they're performing. So to the question that Vivek put, let me just first say that practicing lawyers have been challenging tribunals for a long time, and the argument is, yes, the tribunal system is not doing very well, but I've argued before that the problem really is that of the legal system as a whole. All the problems that you identify with tribunals, you could argue, exist in the normal judicial process as well, right? So the last 2 days, if there's been centralization in one person, and we're talking about the Chief Justice of India. If there's abuse of the Master of Roster position, you're talking about the Chief Justice of India. And all the things that we see in the tribunal system exist, and dependency in the main judicial system is even more, right? So this has been the argument of lawyers for a long time, that there are problems there. But I would say this goes back to Dicey, right? So his definition of the rule of law includes this argument against tribunals. And he gets exercised about them because Dicey misunderstands the way the French tribunal system works, and this is your usual Anglo intolerance for anything from the continent. They'll probably finally leave the continent this year, so good for them. But the British have been wiser, as have the Australians. They've understood that Dicey's objections to tribunals don't need to be taken that seriously, and they have spent over a century trying to work out a system by which you have a balance between what matters need to be decided by regular courts and what matters need to be sent to tribunals. So to the extent that both of you are asking for rationalization, I think our system is a mess, and we don't have clear rules for when cases should go to tribunals and when they should come to regular courts. So I think that criticism is well done. I think we need to look for solutions and responses. The court has directed that we do a impact assessment of the functioning of tribunals. But as we think of ways forward, again, as a comparativist, I would say that actually other common law systems have dealt with it in a particular system, in a way. Very quickly, so Vivek referred to, I've only got one published piece on it, Vivek. It's in the Oxford Handbook of the Indian Constitution on Tribunals. What I try and do there is try and make sense of this long period of case law. So the starting point, as Prashant indicated, and I think perhaps why lawyers in India are so antithetical to the idea of tribunals comes from the original moment. And it's very clear. Indira Gandhi, if you look at 323A and 323B, the attempt was, and you have to remember 42nd and 43rd Amendment, this is when she's getting upset that High Court judges are standing up to the judiciary. She's controlled the Supreme Court by that time. So she brings up a way to hollow out the High Court system. Right? So that is very clearly the intent. I don't think they made any bones about it. The Swaran Singh Committee tried to color that in a certain way, but that's how it was taken. And then we know, as with many things, including the fundamental duty duties which are being shoved down our throats by this government, which also is the product of the 42nd Amendment. The 44th Amendment, they didn't have the numbers in the Rajya Sabha to undo everything that was done by Indira Gandhi's government. So this part remained. And then when you talk about the complicity of judges in other projects, again, it's not new. If you look at the first thing, so I'd say there are three broad trends if you look at the cases. So you have the phase from the time the tribunals were introduced. And again, I must say that Prashant's classification is a very useful classification. We've had tax tribunals from the colonial period. You call them classic tribunals. There are designated tribunals. My last submission will be about foreigners tribunals that Nizam talked about. They probably come under classic tribunals because these are under the foreigners order. They were actually created by an order in 1964 and they flow from that. But the tribunals that the court has been concerned with under 323A and B became the subject of the Sampath Kumar case. So in 1985, the Sampath Kumar case is decided by a Chief Justice and a future Chief Justice, again, Justice Rangnath Mishra and Justice Bhagwati. And at that time, it's very interesting how the court acts with the government. I wouldn't say collusion, but in a way that people challenged the tribunals, the administrative tribunals. The court comes up with a fairly specious logic that there would be alternatives to the courts, because the government is very clear on having that. Remember, this is the Indira Gandhi government and the Rajiv Gandhi government after that. So they're continuing the effort of the tribunals, and the court salvages them in Sampath Kumar in a very unsatisfactory way. Very quickly, those problems start emerging. In 1993, there is a judge, that would be the state of Andhra Pradesh, Chief Justice M.N. Rao, who gives a very brave judgment as a High Court judge called Sakinala Harinath, where he says this is violative of basic structure. The Sampath Kumar case just ignores the fact that you've taken away 226 and 32, cannot be done. 4 years later in L. Chandra Kumar, Constitution Bench of the court agrees with much of what Chief Justice Rao said here, and said that the theory of tribunals, that an effective alternative mechanism is wrong. You cannot have substitutes for the courts, and they can only supplement that role. Right? So that's the first phase from 85 to 97. After that, you have all the cases that you both referred to, R. Gandhi, Madras Bar Association 1 and 2, the DRT case, the tax tribunal. Yeah, I'll just very quickly. So that phase goes on all the way till 2014. Right? So in a way, Roger Matthews is not particularly new, because in a way they're reiterating the older cases. And in that sense, there isn't that much new. But here's where I want to just end with the Foreigners Tribunal Act. It is really quite troubling how, as Nizam said, so for things like consumer protection or for tax matters, and if you're not a tax lawyer, then you don't think that that's the most important thing in the world. We can certainly agree that citizenship matters are really critical and crucial. What is stunning is the same judges who express so much concern about the status of people who are appointed to this and where are they going. When they come to the Foreigners Tribunal, they've not only empowered that tribunal in ways to do so. There is no review from a Foreigners Tribunal. We know that people are trained for 4 hours and become people capable of deciding questions of life and death for people. And you have to wonder why that doesn't come in. I think, again, the law-politics distinction, it is so apparent that in the same time that you decided Roger Matthew, and 5 judges spent so much time trying to make sure that people on the tribunals can be aiding the work of courts. It's really troubling that they don't care, and this matter is brought out. Amnesty International's report on the Foreigners Tribunal really makes for very troubling reading when they give you the statistics of how they function. So I guess it's a theme that has come up again. Why is so much attention and legal rigor, 300-page judgment, devoted to something which is part of the same system, and one other aspect is not given that much attention? And I think that's deeply troubling. Last point on Prashant's theory of is this a way for the bureaucracy to come in, and how is this working? In the Oxford Handbook, there's a piece by T.V. Somanathan, who I think was the retired as probably the highest bureaucrat in the country at some level, the PPS to the Prime Minister, has a piece on regulatory institutions and tribunals, and there he refers to, and so since we lawyers think it's the bureaucracy trying to take it over, he comes and says, no, tribunalization is a way to provide post-retirement jobs for judges, right? So I don't know where the truth is. As you alluded, it's somewhere in the middle, but that's where the tensions also come up. Yeah.
Sorry. So before I hand over, thanks Arun and Prashant for. I thought the most impactful of the Roger Matthews ruling, and I think we should take note of that, which could lead to system reform, whether is we have several statutes in India which directly confer appellate jurisdiction on the Supreme Court. The statistics show that almost 20% of Supreme Court's jurisdiction comes from this. So, for example, from the NCLT, it goes to the NCLAT, from NCLAT straight to the Supreme Court, the appellate jurisdiction. Tax statutes, consumer disputes, securities tribunal, telecom regulatory authority of India, all of these statutes, you sidestep the High Court and it's a direct appellate jurisdiction from the tribunal to the Supreme Court. Roger Matthews for the first time says, sorry, this is like, when you are doing this, you're clogging up the Supreme Court and we should spend time debating larger constitution bench issues. We are not meant to be a court of appeal. You necessarily, in our own Indian Supreme Court, we remanded the matter back to Parliament. They said Parliament must amend these statutes and come back to us within 6 months. So Parliament is like a RDO who will take the decision of this thing. But forget the reasoning aside, the direction is, and that's what I meant by, it's not like a conferring of writ jurisdiction. The addition which Roger Matthews makes is that the appellate jurisdiction also has to travel through the High Court, which means the entire point of tribunals was that, you decide these issues faster. That's the issue which I think is the most impactful one. I just want to know from both the panelists how that would affect the future of tribunals in this country. Like, the entire reason was speed. Now, if you necessarily have to travel to the High Court, which I think is a good thing, but a lot of other people differ. I just wanted to hear from both the panelists on whether that will have changed the future of tribunalization.
The reason it's happened that, high courts have had to, high courts were given that power, I think, was because in 1996 when Chandra Kumar was decided, there seems to have been a general crisis of confidence about tribunals amongst both the bar and the bench. Lawyers were not happy and clearly even the judges were not happy. And the question is whether this position has changed significantly over the last 24 years. And I think most lawyers and judges would still argue that nothing much has changed over the last 24 years. And high courts seem to enjoy much more institutional legitimacy than tribunals. Perhaps the culture that's built up over 150 years. Since high courts were the oldest judicial institutions in the country from 1861. So I don't see this position changing anytime soon unless people like the bar and the bench are more convinced about the legitimacy of these tribunals. They're not able to overcome that crisis of legitimacy that they've been facing since they were created. So I don't think it's going to happen anytime soon.
Very quickly, I think, again, the answer can be found. I don't think we know now. There's extensive work on what constitutes the docket of the court. There are many scholars working on it. Some of them are in the room. The single biggest factor which accounts for the Supreme Court's docket is SLPs. That's a discretionary remedy. Again, this is why I keep saying, I was a practicing lawyer, but more than 20 years ago. So I think this idea that if we can just build systems, I think the restraint has to come from the Supreme Court bar and the bench. Stop filing SLPs, stop admitting SLPs. You'll have a draft. The Constitutional Court can be revived, can be salvaged, if that is the main sort of factor. So I would want to see the empirical count of it, of how many matters come up from the tribunals and where that comes up. But really, I think these changes are very difficult to bring out. The court keeps pushing it to other people to sort of do it. But the court's own approach, under the Gogoi Court, pendency increased. We have the largest Supreme Court ever. The pendency is just increasing anymore. So I don't think the answer is reform is not with other things. I think we also think of the political economy of the bar And the same people who will give lectures at this place saying there's too much problems there, you look at their own practice and where they are generating litigation, unnecessary litigation, the facts tell us otherwise. Right? So I don't think I've said this in the piece and I will say this again, this kind of a reform, the principal people behind it have to be the bar and the bench. Please think of all the tribunal cases, they're all brought by the Delhi Bar Association, the Madras Bar Association. Now the tribunals have their own bars. So and that's going to create a different political economy there. So let's not make this about, the court versus tribunals, right? Those fuzzy lines are not there. I think this is a systemic question. It goes down to also in the way our bar is disciplined, norms of professional regulation, whether there are, again, Justice Bobde, who seems to come up with a bright idea every other day, whether it's artificial independence or artificial intelligence. Artificial independence may not be a bad thing. Yes, may not be a bad thing. Or how lawyers' fees should be regulated. We are acknowledging these things are problems which create the crisis that we have, and which is a very unique crisis. That's where comparative insight will not help there, because ours is such a peculiar model. But it's not just about fixing one downstream effect or the other. I think we really need to think about it much broader. There is really, as Upendra Bakshi said in 1982, if there was a crisis in 1982, that crisis is far deeper, as we are beginning to talk about, and therefore we need to think about maybe really, in that sense, a holistic approach to what is causing these issues.
Sure. I think there's another session scheduled, so we're running out of time. So I'm sorry we can't have discussion. John warned me against that, so we'll conclude the session with this. Apologies if I couldn't take questions.
I'm sorry, the burden of previous delays fell on the last panel, so we can't really have the Q&A since many of our speakers need to take flights. But just before we disperse, I wanted to say a couple of things. The APU students, I think Sudhir wants to have an interaction with you. I think he's not able to meet you in Bangalore very frequently. So just stay on. And before the others disperse, I quickly just want to thank the student team who has put together this program. So I can't name everybody. I haven't taught the first and second year, so I don't remember your names, I'm sorry. But the ones at least I know have been working on this very hard. Sayan, Aishwarya, Priyamvada, Dayar, Sughosh, Bhavisha, Gayatri, Mohini, Geetika, Kanu, Siddharth Sunil, Anushri, Aparajita, Vishal, Raghunandan, Jonathan, Pallavi. I think it's basically their event. It's basically they're the ones who put this together. Because when you host a program in Nalsar, apart from worrying about which speakers you're calling, just the logistics of doing an event here involve a lot more planning than what possibly is required in other urban metropolitan locations. No reference to any of our alumni who are in other institutions. But very quickly, I just wanted to say a couple of things about ideas or suggestions that people may have for the future of this conference. This is the second time we are doing it. There were a lot of repeat players, some new faces this time. We do hope to continue this association with Azim Premji. Both Ram and Arun have promised that they are interested in this project, so are we. And the Law and Other Things blog, of course, has taken on a different color since it came to Nalsar 3 years ago. So we do see this as a long-term project where we can at least have an annual forum to reflect on the growth of Indian constitutionalism. There might be changes in dates as we come to the next year's event. But if you have specific feedback or suggestions on where we can improve, just feel free to write to us, right? So you have my personal ID, you have the Courts and Constitution ID. We'll keep collecting suggestions throughout the year, and then we'll get in touch with you maybe closer to October to plan for next year. So thank you everyone, and see you next year.